Good day, everyone. This is the continuation of interpretation of contract. So in Article 1371, in order to judge the intention of the contracting parties, their contemporaneous and subsequent acts shall be principally considered. Contemporaneous and subsequent acts to be principally considered, while intentions involve a state of mind which may sometimes be difficult to decipher. The act of the parties as well as the evidentiary facts as proved and admitted can be reflective of one's intention. The real nature of contract may be determined not only from express terms of the written agreement, but also by all surrounding circumstances to prove the intention of the parties. First, where the parties to a contract have given a practical constructions to the terms thereof by their contemporaneous or subsequent conduct, as by act in partial performance, such as interpretation may be considered by the court in determining its meaning and ascertaining the intention of the parties, when such intention cannot clearly be ascertained from the words used in their contract. Second, the court are not bound to rely upon the name or title given the contract by the parties, and the essence of the contract determines what law should apply between the contracting parties. So here the illustrative case. The conflicting terminologies in a document create doubt as to whether it is mere loan with security or pact to the retro sale, but the circumstances reveal the real nature of the contract. In fact, in 1927, S executed a document which stated that needing money, he thought of selling a piece of land to B for 225 pesos, that the land could be conveyed in 10 years and that in meantime S would be responsible for all the leniency matters over the land. In 1948, S filed a complaint for the conveyance of the property. B claimed and S had filed to exercise the right to repurchase within 10 years, and therefore, avendi a retro, he had become the owner of the land. In antecedent circumstances relevant in determination of intention. Although Article 1371 speaks of acts contemporaneous and subsequent to the celebration of the contract, antecedent circumstances under which it was made may also be considered. It is well settled that is construing a writing, particularly a written agreement. The reason behind and circumstances surrounding its execution are of paramount importance to place the interpreter in the situation occupied by the parties concerned at the time and the writing was executed. And we have here the illustrative case. The parties for many years had understood the free ride privilege as granted only to those wearing official badge. In fact, under a franchise which is in the nature of contract granted by the City of Manila for the construction and maintenance of street railway system, employees of the police and fire departments of the city shall be entitled to ride free upon the Meralco cars. For 9 years, the parties had understood the provision giving the privilege of the free ride as granted only to those wearing official badges, visibly during the period of transportations. In court not bound by name given to contract by the parties. To determine the true nature of a contract, courts do not have or are not bound to rely upon the name or title given it by the contracting parties should there be a controversy as to what they really intended to enter into. The way the contracting parties do or perform their respective obligation stipulated or agreed upon may be shown and inquired into, and should such performance conflict with the name or title given the contract by the parties, the former must prevail over the latter. Therefore, the documentary and parole evidence may be submitted and admitted to prove the true intention of the parties as shown by their words, conduct, and act before, during, and immediately after the execution of the contract. The true nature of contract defined by law. A contract is what the law defines it to be, considering its essential elements, and not what it is called by the contracting parties. It is not the parties but the law that determines the juridical situation created by them through their contract and the rights and obligations arising therefrom. So we have here the light of circumstances and the fact in the record. First, a pact to direct through sale may be construed as a simple loan or equitable mortgage under Article 1602 of the Civil Code. Second, a contract to sell real estate may be considered a contract for the redemption of mortgage property. Third, although in the contract the words lease or leasee and lessor are employed, that is no obstacle to holding that said contract is really a sale on installments if such was the evident intention of the parties in entering into the said contract. Fourth, notwithstanding its denomination or designation as a contract of lease, its provision and the contemporaneous act of the contracting parties may disclose that the intent of the parties is to make the lessor or an independent contractor for a piece of work. Lastly, the fact that the document in question is entitled exclusively option to purchase is not controlling where the text thereby shows that it is a contract to sale. And the true nature of contract defined by law. A contract is what the law defines it to be, considering its essential elements, and not what it is called by the contracting parties. It is not the parties but the law that determines the juridical situation created by them through their contract and the rights and obligations arising. So we have here the light of the circumstances, the fact in the record. First, a pact to direct through sale may be construed as a simple loan or equitable mortgage under Article 1602 of the Civil Code. Second, a contract to sell real estate may be considered a contract for redemption of mortgage property. Third, although in the contract the words lease or lease and lessor are employed, that is not obstacle to holding that said contract. Article 1371-679 is really a sale on installments, if such was the evident intention of the parties in entering into the said contract. Fourth, notwithstanding its denomination or designation as a contract of lease, its provision and the contemporaneous act of the contracting parties may disclose that the intent of the party is to make the lessor an independent contractor for a piece of work. Lastly, the fact that the document in questions is entitled exclusive option to purchase is not controlling where the text thereby show that is contract to sell. So we have here the illustrative case. The stipulation in a document entitled barter indicate an intention on the part of the signatories thereto not to convey ownership of their respective properties. In fact, the spouses A and B were owners of residential lot. They executed an agreement entitled barter, whereby they agreed to barter in exchange with spouses C and D the lot with the latter's rice land. Under the agreement, the parties shall enjoy the material possession of their respective properties. A and B shall reap the fruits of the rice land, while C and D shall have the right to build their house on the lot. And in the event any of the children of E, daughter of A and B, shall choose to reside and build his own house on the lot C and D, shall be obliged to return the lot to such children, and that neither party shall encumber, alienate, or dispose of their respective properties without the consent of others. Let's move on. In Article 1372, however general the terms of a contract may be, they shall not be understood to comprehend things that are distinct and cases that are different from those upon which the parties intended to agree. In special intent prevails over a general intent. As a rule, where in a contract there are general and special provisions covering the same subject matter and inconsistent, the latter shall be paramount to an control over the former when the two cannot stand together. The reason for this rule is that when the parties express themselves in reference to a particular matter, the attention is directed to that, and it must be assumed that it expresses their intent, whereas a reference to some general matter within which the particular matter may be included does not necessarily indicate that the parties had that particular matter in mind. So here the Article 1373. If some stipulation of any contract should admit of several Meanings, it shall be understood as bearing that imports which is most adequate to render it effectual. In interpretation of a stipulation with several meanings, when an agreement is susceptible of several meanings, one of which would render it effectual, it should be given that interpretation. Thus, if one interpretation makes a contract valid or effective, and the other makes it illegal or meaningless, the former interpretation is one which is warranted by the rule stated in Article 1373. Also in Article 1374, the various stipulation of a contract shall be interpreted together, attributing to the doubtful ones that sense which may result from all of them taken jointly. Interpretation of various stipulations separate writings of contract. First, conflicting provision of contract. As in statutes, the provision of contract should not be read in isolation from the rest of instrument, but on the contrary, interpreted in the light of other related provisions. And contract contained in several documents. Where the contract is contained in several documents or in two or more separate writings, all of them must be taken together to determine the intention of the parties. Third, business forms. Business forms, order slip, delivery charge, invoice, and the like, which are issued by the seller in the ordinary course of business, are not always fully accomplished to contain all the necessary information describing in detail the whole business transaction. Fourth, titles or separability clause in contract. Titles given to sections of contract may be restored to the purpose of determining the scope of the provision and the relation to other portion thereof. Two separate sections or articles of a contract cannot be correlated with each other where the parties have expressly provided for separability clause. That one article cannot have restrictive effect upon the meaning of another article. So we have here the illustrative case. Stipulation and language employed in a bill of assignment of a formula indicate an intention to transfer only the use of the formula. In fact, P executed a bill of assignment in favor of UFC, which recites, among others, that a patentee P assigns, transfers, and conveys all his property rights and interests over said Mafran trademark and formula of Mafran sauce into UFC, and that such assignment transfer the conveyance is absolute and irrevocable, and in no case shall P ask, demand, or sue for the surrender of his rights and interests over said Mafran trademark and formula.